Good afternoon, everybody. As announced in this week, we will interact with this a PowerPoint presentation. So you are required to visit the website provided by a School of Administration, and you listen the audio lecture. So the class will be regularly on this basis for 2 hours class in Thursday, and we will meet in person on Monday. As you introduced in the last class, this term will be devoted to American legal system and legal research. It's actually the class title would be in Korea, so it might confuse you in some ambiguously about the frame and class purpose. You will also be advised to refer to the class introduction, perhaps available in the website of university. So your mind need to be focused on the method of legal research, and also some great documents to make you some comprehensive flavor about the system. As I stressed, it would be beyond the scope ambit, given we expect any specific deals with legal rules or laws, case laws, the statute, or the constitutional what kind of issues in any more or that. So please regard the details, and the principal objective of this class will direct you to the basic feature of American legal system, and also some British heritage now also in influence to shape the American legal system, and also some historical perspective in a complement with a comparative viewpoint would also facilitate our purpose in through the end of this term. And you are expected to have a learning outcome in the rest of this term comprehensively. And I also remind you some point you need to focus. So the weekly basis about learning outcome would be introduced for your grasp of this class. In week 3, our attention will be given to primary legal sources. There are a scope of a primary legal sources in terms of legal research. So you will expect, for example, the Constitution of the United States, and also the court cases would be primary. Typically important since they now manage the common law legal system and principle and rules, as the statute says, and the doctrine of precedent is very embedded to create now the kind of one major civil legislation in the United States and other common law countries, and the distribution is extensive. And might you be more familiar with the kind of world history, imperialism, and the concept of legal implant is often adequate to understand the backdrop considered. And what are other preserve you imagine as a primary legal sources in terms of legal research? So we have some brief about a second source last week. Actually, a second source is quite useful to serve as excellent starting point for legal research, because it offers the background information through analysis or commentary. And so you may find any useful citations about the court cases. So that is good basis to engineer in any initial stage your research purpose. Of course, in some cases, the law-review articles may not provide any adequate scope of a citations, and it might be curtailed to serve the purpose of author. Nonetheless, one is a good reference to fuel the basis of research. So you may be definite about case name, for example, and you also have some introduction about a way of search. You may think about some key term search, for example. It would be often common to expand your horizon, since it would not be in any restraint priorly. So the key term search would expose you extensive sources of documents pertinent to your research. So that is one strength if you implement a key term search. The other way, you will apply a case name search, which is actually one way if you know the case name exactly. So, and you will need in some occasion to refer to the case specifically, since you are now entangled with some important research question, and the case would be quite controlling to settle your inquisition or the kind of a controversies. So in that case, you would be helped by applying a case name search. And one other way would be to use the citation search. So the citation system has been instituted very systematically in the last century, beginning of the last century. And also we will have a historical information about that point. For example, what is that? English case reporter. And you also will be instructed with kind of a comparative legal system about case reporting. So the historical evolution, for example, between the commercial establishments and government branches, who actually is ultimately responsible to report the case. Of course, the expertise would be essential to marshal and select cases. So what is the final scope to be reportable? The kind of question need to be resolved, and also employ some commercial establishments to facilitate a business of a judiciary. So the kind of history is important in understanding legal system comparatively, and you will also have some more ordinance system, often monopolized by government in continental legal system, and the judicial style will differ in this scope. And the practice from Great Britain will be resembled by United States, and of course the national legal system is quite distinct, so that the kind of evolution is quite autonomous within the territory, within the American legal system. So in earlier of 19th centuries, the United States has some independent efforts to address the challenges from case reporting. For example, Pennsylvania, state of Pennsylvania has initiated to report a case in systemic way. In that case, we have some interesting point of notion between the normative case reporting, nominative case reporting, and the number-based case reporting. So the legal system is actually should not be shortened in the United States, since the legal demands are quite tremendous to cover the large territory and growing populace. So the cases would be flooded in soon after independence, and it would expand actually. So the case reporting is quite demanding a business of government, and made be systematic by assigning the official number, and that would now be used as a citation in your research article. So you can see some differences across the time of documents. So the formality would differ most strikingly in the first place, and the volume would differ. For example, the whole of books to cover 500 or 600 years would be reduced to a series of 100 of about 100 books and others. These days I have been noticed I've noticed some work Halsbury English Legal Encyclopedia, actually compiled by LexisNexis. So it offers good work of reference if you are research of legal history, for example. So the case reporting system is actually determinative in terms of legal researches. So the legal researcher would highly depend on the kind of system now often provided in the kind of monopoly by LexisNexis and Westlaw, two major institutions who come in your come in your general use, and the quality of service would also be very strong than other sources. So the resources available to legal researcher would be extensive. So, and from the kind of a treatise, a horn book, through the manual or nutshell, a kind of a summary form of legal information, and you will be given the kind of a basic points about that scope in contents. So, well, the encyclopedia, for example, would be quite useful source. What you may imagine, for example, Wikipedia, which is lay in nature, but quite exquisite and expositive about topic, kind of a textbook for college students. And you may have some basic information necessary to begin your legal research from this source. Nonetheless, still need to be cautioned, since it could not such authoritative like against kind of a low regard, because more processed products. For example, restatement is quite sick. And also you will have some point of distinction about sorts of encyclopedia. Wikipedia Britannica is general in deals. Nonetheless, the legal encyclopedia would make more effect to subsidize your need of research, I suppose, since it is legal, and you will have some very familiar terms and concepts often delivered over your legal education. So you would have some fossil associated with the kind of sources, and actually we would not disregard the role of encyclopedia in legal research. Even the ultimate authority, such as the Supreme Court of the United States, might begin their discussion or the kind of a legal reasoning by referring to the kind of legal encyclopedia. Dictionary is also a good source. For example, you may think about the definition of fetus, for example. How dictionary gives us its definition. So you know the kind of important decision about right of abortion, Roe versus Wade, decided in 1970. It is very impacting the subsequent developing case laws. The consequences serious. Parenthood versus state, in what condition and situation the pregnant woman could legitimately perform can receive the abortion operation, for example. So 3 months in pregnancy or 8 months in pregnancy, the kind of a substantiation, and it would be law to weigh between the life of fetus and the right of privacy, maternal privacy. So then what is the fetus? Is it life? Actually, the interest often is quite serious about life. Right? It is actually most precious in our public business. Is kind of death penalty will also be debated in the Constitution Court. Is the state authority legitimate to deliver death penalty, for example? What is a life interest of fetus? So we need to weigh. And then what is fetus and what is human being, to be shielded from constitutional protection. Constitutional. Actually, do you see a constitution? So the definition might be confused. In that case, we, of course, it is not determinative. If the dictionary would result in contrary concept about life or human being, it is but eventually determined by in terms of a law and judicial standards. So the Supreme Court is ultimate authority to define a human being as a matter of law. Nonetheless, dictionary would be epistemologically authoritative. So good point to cognize a human being in what general and also legal comprehension. So you will be aware of such extended scope of second sources, and what are a restatement, corpus second, for example, and home books, case books, the kind of a newspaper article in some cases. So legal researcher would serve on the sea of second sources to respond with a research goals or purpose. And consider basically in last week, class purpose of last week, what I have presented, what types of sources provide legally binding authority. How do you find these resources? And also, you in the first week you introduced about a general understanding of a U.S. legal system. It practices federalism, and authorities would be made distinct finding in terms of legal research. So you may know the concept, for example, state case laws, federal case laws, and the federal statute, the state statute. You also be introduced some of online websites about state government. So the concept is e-government in these days. So the public access will often not be impeded in many cases. Of course, it depends on public policy. You may know the scope of disclosure of public governmental information actually is regulated by federal statute, FORMA. So that is one point you have been aware, have awareness in the class of last term. And now you enter the third week, so you kickstart an explanation of primary sources. And as you see, the primary sources are in three folds, basically, and what a constitution and public statute and court cases, and you may begin with cases from court systems at the federal and state levels. In doing so, you use online databases and search strategies to locate cold cases. You also examine the hierarchical structure of court systems in order to understand the common law and the weight of authority of cases decided by these courts. So by the end of this week, you should be able to apply online search strategies for court cases and analyze strengths and weaknesses of legal databases and analyze jurisdiction of federal and state courts. Actually, really, this society is informative. Now we talk about kind of a revolution change in our mode of interaction. What a e-government and also the cyberspace is important forum for the intellectuals in many senses. And for the legal researcher, there are a scope of a legal databases in internet. The legal databases will differ in nature, scope, coverage, and ways of dealing, and often they would be open to public access freely without any. Once you may experience the kind of ask to donate $5 for a staff person in the Cornell University Legal Information Institute. So or they choose to donate in this case. And often more systemic way of a provision would be found in Westlaw, notably, and LexisNexis also might be secondary and major to open to public use. So it's a kind of a subscription fee would be necessary once we have enjoyed that subscription, but some reason or financial fiscal problem at the university, we now individually subscribe to data. And it would be quite instructive if I may practice visually to explore the websites for others. You may in some cases have some classification about subject matters, for example Supreme Court cases and federal civil federal statute of civil procedure, federal statute of criminal procedure, federal rules of evidence, and federal rules of civil procedure, and many others which are now available if you access to the Cornell University Legal Information Institute and other quasi nature of a commons is now popular. Final outcome, for example, would be notorious to serve the need of a practitioner attorneys. So they actually manage the scope business to subsidize the needs of researchers, lawyers, and so law firms, and now it is virtually indispensable. For example, the information about lawyers and their specialty and their reputation is offered on online basis. So client will seek a better attorney, as the attorney would seek a better law to be applied to the specific dispute. And a final outcome is one branch business controlled by Westlaw, and they provide a summary of case laws, and in some cases might be linked to the PDF version of court cases, and original form of court opinion would be available to your reference. So quite useful, and you may well apply a series of a search method to locate your case, and the case will be often helpful authority to resolve your legal question, research question, since they are common law country. It is authority and binding. Actually, often recognized uniquely as a law in the common law system. A statute would be a piecemeal, it is not exactly of all the scope of all the areas of law. In domain of public law, the statute in the United States is quite controlling. However, you will see a limited provision about traditional areas of this law, tort law, contract law, often is tapped with a kind of a massive case laws, and actually the business of common law lawyers would be deal with precedents, so they need to know the court opinion and legal reasoning, what is the main holding of court, and what is the opinions for the conclusion, and how do we distinguish among similar cases. So what is the law in the specific case? That is concept. So we call often a judge-made law to as one of important attributes in the common law system. Judge is a generator of law in the common law legal system. That comes different way in the civil law tradition. We often know this provision of statute, executive orders, the kind of a abstract nature of a laws would be law, and the judge would only be responsible to interpret the abstract language. The distinction is quite intellectual in many senses, and that therefore is profound in many cases. In some cases, the common law judge will question how this is law. We have some civil code in the comprehension. It seems to be a constitution, United States Constitution, or the private matters. There are very refined nature of a provision determined by legislature. So they rather consider that kind of quasi-constitution, a property which is prepared to meet the civil society, property right, a freedom contract, basic theory of total liability. They look up case laws. In the first instance, they say it is law. Of course, the political expression is what controlling. If two areas of concern would overlap, what in kind of mirroring, so exactly same. We have no avenue to be repugnant to the will of a political branch. That will be law in that case. Nonetheless, they still have authority to make law within the statutory language. So that is way of intelligence to approach and ways of thinking and daily thinking, and their business is on inductive reasoning. So very inquisitive over similar cases in distinguishing and analyzing. So this is law, and it is a generator of law, and that is also another precedent to be respected by a subsequent court. So institutional insulation, as you see in the legal history of West, quite actually in result. So no revolution, like France or United States. Of course, United States has imported electric after the national independence. So you also may know persecution of revolutionary force about a judicial branch in France. So now judicial branch is relegated seriously, fundamentally. It must be subject to political will of people. Often judicial people in the medieval times is kind of nobility, warrior nobility and second nature of nobility, and very intellectually, and often important steps to support the might of king. For example, you know the history of Star Chamber. In medieval days, they practice two nature powers to serve the purpose of king, legislation and administrative justice. And also, you may know the word court originate from kind of cabinet. So actually, it has in favor or to cover all the branches. Now you see in the constitutional chapter separate, independently of the legislature and judiciary. The court is the forum that the national law is created, and also national justice of national administration is administered. The common law code would be situated quite in advantage about insulation and independence. Of course, we have another history in some aspect about persecution. Common law justice may be persecuted. The ideas is, however, quite intellectual, to be imported by a new asserting North American continent. So Sir Blackstone, he is a figure of 18th century, and earlier for that idea, kind of a basics to lay foundation about judicial responsibility or the structure of government. It's Edmund Koch, kind of higher concept and higher law concept, and the kind of notion would not be relevant in understanding the legal system of the United States, and you are now introduced to that trend in understanding legal system and legal research. Legal research would not be separated from a legal system, and legal system also would be interwoven with legal history. The kind of a triad is mutually enforcing to realize our reality in this case, in this profession. So actually I'm novice on this mode of lecture. This is the first time to use this technology. I've once been aided by tech fixers about the default of the system. So I may regret if this presentation is some course, and I will develop my skills by practice. In any case, we'll have a short break, and I would introduce some of basics about core system, and you will take some representative passages, kind of famous words from jurists or historical figures, and also basic points about state legal system in the United States and earlier. Actually, United States is a protege from a British legal tradition. Of course, they're delegated at most extent since the law is nationalistic. Still, the earlier precedent has an impact in founding the basics of law in specific area. So that kind of dealings would actually traditional to serve this class purpose. My intention is to intermingle the piecemeal deals of some remarked materials or passages, documents, with the contemporary nature of legal research. So that would allow you to have basic comprehension of American legal system, which is the title of this class. Okay, we'll have a short break, and I'll come back soon.